Hello. So today we're going to start with another area which is very relevant to the company law, which will help us to identify the nature and the characteristic of a company. So we're going to start with the first characteristic, which is the separate legal entity. Now, separate legal entity means that the company is distinct from the people who have formed it. So basically, if I am a shareholder of a company, I cannot say that I am a company. So whenever the company is incorporated, then the new entity has been created, and that entity have the different recognition altogether. They, they do not have the synonym term with that of the owners of the company. So by that means the company can own a property. So company may have its own offices, its building, its machines, its cars, its goodwill, its reputation. Then company may borrow money in its name from financial institution or the banks. Company may have its own bank account. So you can have the company may have its own transaction and the money can be credited to its own bank account. Company may employ people. So the employees are hired by the company on the letterhead of the company and not through the shareholders. Then company may enter into a contract with any person, be it the supplier, be it any other company, be it the LLP, be it the firm, be it any other entity, even governments while paying taxes. Then company can sue and be sued in the manner as similar to the individual. So we have seen various cases in which the company is a party to a suit. Now the question arises that how this origin was been duly recognized. So it was way backdated in the 19th century or maybe towards the end of 19th century when the major case law has taken place in the country, which is United Kingdom. So very leading case of company law with respect to the separate legal entity is the Salomon versus Aaron Salomon Company Limited. The year was 1897. Now I'll take you through some facts of the case. So herein, Aaron Salomon was the sole proprietor of the of in the UK. Now was used to manufacture the shoes, and this is what his main agenda of operation was. Thereafter, he transferred some assets to the sole proprietorship and some liabilities also. So by the means that we have seen that the sole proprietorship is similar to that of the person. So basically, whatever the assets and the sole liabilities of the sole proprietorship was similar to that of the Aaron Salomon. There was no distinction between them. After some point of time, Aaron Salomon incorporated Salomon and Company Limited, and with an intent to actually transfer all the business of sole proprietorship to that of a company. And he did so. He transferred all the assets and the liabilities which he owned through the sole proprietorship, along with the business of manufacturing shoes, to Salomon Company Limited. Now, in return, Salomon Company Limited has given some purchase consideration by way of cash of pounds 9,000, equity share capital of 20,000 pounds, and secured debentures worth 10,000 pounds. So overall consideration of 39,000 pounds. Now, how do we define purchase consideration? It refers to the payment made by a transferee company, that is Salomon Company Limited, to the transfer company, that is Salomon Company Limited, from the business taken over. It includes all type of payment made in the form of shares, securities, bonds, and cash. Herein, I just want to convey that transferee company will be Salomon Company Limited, and transfer company will be the sole proprietorship by means of the ownership of a Aaron Salomon. Now, after some point, Salomon Company Limited came into contract with Edwin Budrick. He was the creditor, and he agreed to give the loan of 5,000 pounds to Salomon Company Limited. Thereafter, the Salmon Company Limited faced some operational issues and it eventually got failed and got liquidated. Now, liquidation means that when the company ceases its operation, its assets are being sold off in order to pay to its stakeholders. Now, we have at that point of time, the Companies Act of 1862 of the UK was applicable and which defined the liquidation of a company. So it says liquidating a company refers to the procedure in which a limited company is brought to a closure. The company's assets are then sold, which is liquidated, and any realization of the revenue is redistributed in the order of the priority. So the first one to receive the payment will be the secured creditors, then the unsecured creditors, and then the shareholders. Now, how do you define the secured and the unsecured creditors? So, a secured creditor is a creditor that has lien on an item of the company's property. A lien is an interest in the property that allows a creditor to have company's property sold to satisfy their debt, such as bank or mortgage lenders. An unsecured creditor is the creditor who have no interest in any of the particular property of a company, such as supplier or the customer. Now, at the time of liquidation, the company's assets were being sold off, and the amount which has been realized from the selling of the assets were only £6,000. Whereas, as you can see, there are three parties who are entitled to receive the money from the company after its liquidation, which is the secured creditor, the creditor, and the equity shareholder. So, while applying the Companies Act of 1862, we can see that the repayment priority number one will be of secured creditor, priority two will be creditor, and priority three will be equity shareholder. That is why the entire amount of £6,000 was being paid to Salomon in the order of first priority because he was having the £10,000 of secured debentures. That is why after this the company is left with no money whatsoever. Now, the issue which arose in the petition filed by Edmund Bedrip in the court of law was he framed that Aaron Salomon from the company, the Salomon Co., to receive the creditors. Salomon is the agent of the Salomon Company Limited, and Salomon should be held liable for the company's debt over and above his capital contribution as to expose him to the unlimited personal liability. That was his contention. Now, the decision which upheld the meaning of separate legal entity, basically the principle of separate legal entity, stated the point that the company is a separate legal entity, which is distinct from its members, so insulating Mr. Salomon, the founder of Salomon Company Limited, from personal liability to the creditors of the company he founded. The court also upheld firmly the doctrine of corporate personality as set out in the Companies Act of 1862, so that the creditors of an insolvent company could not sue the company's shareholder to pay the outstanding debt. So basically, herein the company was being protected as a separate legal entity. Now, thereafter, the decision was been solidified in the Lee versus Lee Air Farming Company Limited, which will be talked about in the another video. Now, herein, the second characteristic is the limited liability. That means companies, the shareholders who own some interest in the company, they have the liability limited to the extent of their shareholding. So basically, there are two types of companies, which is the company limited by shares, in which the liability of the members is limited to the amount of value they have subscribed. So herein, like we can see that there's a shareholder who has purchased the shares worth 10,000 rupee, and by which he got 1,000 shares of 10 rupee each. Now herein, if the company goes into liquidation, his liability will remain only of 10,000 rupee. Nothing besides that, nothing's over that. So that will be the extent which is limited. Similarly, in case of guarantee is a type of another company in which the member can specify his limit in case of liquidation. So basically, the specification is mentioned in the memorandum of a company, wherein all the members of the companies, how many numbers are there, they need to specify that how much amount of liability they can bear if the company goes into liquidation. So if the member mentions that he can take care of 10,000 rupee by way of the guarantee that he's willing to give, and the company goes into liquidation, then only 10,000 of fee will be paid by the member. Now, there are some exceptions to the limited liability. So, these are if the company has been incorporated as the unlimited company under Section 3, Subsection 2, Clause C of the Companies Act of 2013. So, unlimited company, as the name says, the shareholders or the members of the company have the unlimited liability. That means the personal assets can be reached upon if the company goes into liquidation. Then the prospectus of a company has been issued with the intent to defraud the applicants. Then when any false or the incorrect statement have been published or furnished at the time of incorporation, then when there is fraud committed in the operations of the company. So we can see some examples. So there are 3 examples given here. Rana Kapoor, who was the executive director of the Yes Bank, his 3 properties, which is personal assets, came into the enforcement directorate scanner when the Yes Bank has released some or unrestricted their NPAs in the financial statements. Similarly, Vijay Mallya's property was confiscated when Kingfisher went for liquidation. Then Nirav Modi property of rupees 2,400 crores was likely to be confiscated because of the fraud that he has committed through the PNB. Then the company is having a perpetual succession. That means that the death of any member, any shareholder, any director, any CEO, CXO level employees will not affect the succession of a company. The company will continue even if the person is alive or not. So the company is having a perpetual succession. Perpetual means forever. Succession means the continuity. Now there is a fundamental regarding this, that the company has been created under the privileges of the law, and only the law can dissolve it. So with the help of law, the company can be dissolved. No member, no shareholder have a right to dissolve the company. There was a case law, leading case law of K9 Milk Supplies Gulfur Limited in the year 1966, when the board of directors of the company was sitting in a room which was bombed and everyone died therein. Now the creators of the company filed a petition for the liquidation of the company, and the court has said the point that even the hydrogen bomb cannot destroy the company. So the company's leadership or the management will go to the legal heirs or the appropriate directors who can be reappointed by the government or the intervention of the government. When the company is having a separate property, that means they can own the land, building, plant, machinery, and whatever that is, that can be owned by the person. So they are having a separate property. Even the liabilities also can be owned by the company. That means that no member, no shareholders can have the equitable claim on the company's property. And you can see from the leading case of Mercura versus Northern Insurance Co. Company Limited, which is in the year 925, in which the court has upheld the very basic fundamental of the members do not have an interest in the company's property. Now, here in this case, the facts were the owner of a timber state sold all of the timber to a company which was owned almost solely by him. He was the largest creditor. He insured the company against fire, but in his own name. After the timber was destroyed by the fire, the insurance company refused the claim. Now, the decision, the House of Law held that in order to have an insurable interest in the property, a person must have legal or equitable interest in the property. The claim field as the corporator, the person basically, even if he holds all the shares in the corporation, neither he or any creditor of the company has property legal or equitable in the assets of the company. So it was being solidified that no members have equitable rights in the company's property. Transferability of the shares. So in a public company, the shares can be freely transferable. That means if I'm the owner of a share of the public company, then I can transfer my interest to any other person who is willing to buy the shares of a company. Now, transferability of the shares is contained under Section 44. It says that the shares or debenture or any other interest of a member in a company shall be movable property. And then it means that it can be transferred by way of the procedure defined in the articles of the company. The procedure of transfer is enlisted under Section 56 of the Companies Act of 2013. The pertinent document with regard to the procedure will be uploaded on the content of the course. And the company is having the capacity to sue or be sued. So basically, the company can knock the doors of the court, be it the Supreme Court or be it the High Court, and get its petition to be entertained by the courts. Now, company in the case of Floating Services Limited versus MV San Francisco de Palau in the year 2004, it was stated that the company has a right to sue when some loss is caused to the company's property or the personality. Personality will include the goodwill of a company or the reputation, and when it has been caused through the libel or the slander, which is the part of the defamation. So a company can sue any of the person in case of if there is any damages which has been caused to its property or its personality. Then the company is having a common seal. Now company is basically an artificial entity. It cannot sign because the sign is basically executed by the natural person. So that means the company is having its own signature by way of common seal. Common seal looks like this, which is a rubber stamp and which can be used by the companies to actually sign on the authenticated documents or to authenticate the documents. Basically, any document which has been signed or the company seal is affixed, then this documents will become binding on the company as the way and the document signed by the person becomes binding on them. So here are the traits and the characteristics of the company. The relevant documents will be uploaded. And the next, the Lee versus Lee farming will be dealt with in the another video. Thank you so much.